Great. So hi everybody, greetings from Istanbul. I am Aslı Karaca. I wish you a productive and enjoyable conference and conversation and time in Beirut. I'm sorry I'm not with you this time, but I hope to join to the next Pluriel event. I have been following the conversations, the presentations since yesterday. It is really engaging. I wish I was there. And I would like to thank Pluriel for hosting me in this wonderful event. And I also would like to thank my former student from Al-Quds University, Zain Atik, who assisted me in analyzing the Palestinian case. Let me start. My topic today is on institutionalized Islam in personal status laws and challenge position of women as the other. In most of the Muslim majority countries, personal status laws are the main domain where Islam has been institutionalized. By the way, Ali, can you remind me at 10 minutes, in 10 minutes?
Yeah, you can, no more than 20 minutes you can get. So,
yeah, just I want to make sure like I'm on time.
Yeah, 20 minutes, 25 minutes maximum.
Tamam. But please remind me when it's like 10 minutes, can you tell me?
I can remind you.
Yeah, great. In most of the Muslim majority countries, personal status laws are the main domain where Islam has been institutionalized. Personal status laws defines the relations between men and women, including the rights of the parties in marriage, divorce, child custody, and inheritance. Since men and women relationship has not been based on equality in these laws, but on traditional and historical responsibilities and duties of men and women, which are often announced as Islamic, women have become the other or the secondary party in the Islamic personal status laws, while men can be classified as the main party. I will overview the general features of Islamic personal status laws, and I will mention some features of the laws applied in Egypt and the occupied Palestinian territories and contestations around them. I am asking in general, can we discuss religion without the politics, with its current legal and institutional forms and formal and informal stakeholders on the ground? Can we separate religion from the political rivalries in the context? In particular, what does the Khola reform in 2000 in Egyptian personal status laws mean in defining the rights of women? In the Palestinian context, what does an insistence to use Islamic Sharia in personal status laws mean? In a nation which tries to build its own sovereignty through administrative apparatus and legal framework, will Palestinians keep using the Jordanian and Egyptian Sharia-based personal status laws, or will they strive to find a unified personal status laws for the Christian and Muslim Palestinians under equal terms? Here, the main conflict is between two contradictory forces in nation-state building. One that is which, at least in paper, claim to provide equal citizenship to its people, and the other which tries to fit in the demands of cultural authenticity, especially women as the carriers of cultural authenticity are affected in these demands. So, personal status laws are the place we see these contestations between the different political actors and stakeholders in the political arena. Recent sociopolitical upheavals in the Middle East and North Africa have activated the debates about reforming the existing patterns of relationship between religion and politics. The personal status laws in this regard have been the epitome of the debates in the MENA. These laws have been the first target of women's movements who hope to alter or transform the status of women, but they're also the target of the Islamist and conservative groups who hope to further Islamicize the legal frameworks during the state reformation or formation process, as in the case of Palestine. It has been recorded by several observers that the situation of women and minorities, the others, often remains untouched in nation building, democratic transitions, or regime changes, while other fields, such as electoral systems or the allocation of power between classes and elites, undergo drastic changes. The continuous separation of personal status laws from the rest of the legal system is an example of the gender regime that has remained intact even as electoral regimes and constitutions have changed in many of those MENA countries. In existing Islamic personal status laws in Egypt and Palestine, the marriages are not based on equality, but they are based on a relationship of women's obedience in exchange for man's financial maintenance. So, women needs to obey and serve the household, and man has to maintain the household and expenses of women financially. This is their duties reciprocally. The Christian populations in Egypt and Palestine has their own personal status laws or statutes, while the rest of the legal system is secularized, especially in Egypt, mainly based on the Napoleonic Code. Personal status laws are still governed by religious principles. The existing legal arrangements shows a deep contradiction between the religious-based personal status laws and the Constitution of Egypt on the one side, and the basic law accepted by Palestinian Authority, and the international human rights framework that both Egypt and Palestinian Authority have signed, which ensures gender equality. So there's a contradiction between personal status laws and existing national framework, constitution and basic laws. We should also add to this the complicating impact of statelessness, legal ambiguity under occupation, and separate legal frameworks in West Bank and Gaza when it comes to understand the other in personal status laws. So, what makes the women the other? Let's look at some concrete examples from the ground. So now I will compare Egypt, West Bank, and Gaza. So we have three legal frameworks here. So in Egypt, we have several laws enacted starting from 1920s. An important reform happened in 1985 and also in 2000, known as Hula reform. And also there was a last reform in 2005 regarding the age of custody, child's custody. In the West Bank, we see that Palestinians use the Jordanian personal status law of 1976. And in Gaza, we see the Gazan Palestinians use the Egyptian family rights law of 1954, which is based on the Ottoman law of family rights from the early 20th century. Both laws have been amended and supplemented by the relevant Palestinian authorities, but they serve as the basis of the personal status laws for Palestinians. So I want to look at, for example, the issue of guardianship. This is very important. Male guardianship, known as in Arabic as wali. Basically, in most of the Muslim personal status laws, women need a Muslim male relative of them to represent them legally, especially when they sign marriage contracts. Basically, this means women are regarded as legal minors in many Islamic-based personal status law. This is coming from the Kiwama and Wilaya concepts in Quran. I will not go into detail in that. I mean, the legal jurisprudence based this law in this concepts in Quran. Let's look at Egypt. In Egypt, women has the right to contract their marriage without a guardian. However, on the ground, the marriage register, Ma'zun, may refuse to allow women to contract their own marriage and demand a male guardian on her behalf. This is according to the law number 1 of 2000. Basically, the court may accept request to examine whether women need a consent of a guardian to enter into a marriage contract. However, this is in contrary to the existing constitution, Article 11, which recognizes women as full citizens. So we have here our first contradiction. Secondly, although the full testimony of women is recognized before the penal courts, under the personal status law, the testimonies of 2 females is equal to 1 male testimony in the marriage contract or before the family court. So we also here have a discrimination against women in terms of testimony in family courts and marriage contracts. When we look at West Bank and Gaza, we see that in both in both contexts, the women and men do not have equal capacity to enter into marriages. So women, regardless of their age, still require the permission of a male guardian to get married, whereas men do not have this need to get a permission. As Zeyna Jallat says, quote, "A Palestinian woman can be a judge, a representative in the Palestinian Legislative Council, a businesswoman, or assume other high-level decision-making positions, but she cannot stand for herself when it comes to the right to enter into marriage," end of quote. Also, in Palestine, a male guardian can decide whether or not a female, an unmarried female under the age of 40, of whom he is a guardian, should live with him or not. So he has the discretion to decide whether an unmarried female under his guardianship can live alone or not. So this again eliminates a women's choice of housing and living independently when they are not married. Let's look at the issue of divorce. First of all, man has unilateral right to divorce in three contexts: Egypt, West Bank, and Gaza, while women do not have this right to divorce, unilateral right to divorce. Let's look at Egypt. The 1985 law rearranged man's unilateral right to divorce. This is called Rij'i Talak. Men wishing to divorce in Egypt do not have to go to court and give a reason. The 1985 law merely obliged men to notify their wives about their divorce and register it with the register within 30 days. Although the law imposes fines and imprisonment for men who disobey this law, it does not invalidate the divorces which did not comply with these rules. Let's look at Gaza and West Bank. Both in the Gaza Strip and West Bank, men are guaranteed the right to divorce their wives unilaterally without any restrictions. However, in this case, the husbands must inform the wives. In order to make the divorce, the husband must merely express his decision to divorce orally. The wife, however, doesn't even need to be present during the announcement. However, she has to be notified within 1 week. There is a period called Al-Idda, where divorce can be evoked by the husband according to his will. This period lasts for almost 3 months in order to determine whether the wife is pregnant or not. During the Idda, the husband should still provide for the wife with financial needs. However, women can be deprived from this financial support if she was perceived as a disobedient wife. Let's look at the rights of women to divorce. In both Palestine and Egypt, women can file harm-based divorce. So they can go to the court. They have to go to the court and ask from the judge that they are being harmed in the marriage, so they can file for a divorce. However, there are complications. Egyptian courts define what counts as violence beyond the permission given in Islamic Sharia to the husbands. So if the wife is disobedient and if the husband has warned the wife, and later if he separated his bedroom, then if he applied some level of violence, which depends according to the discretion of the judge, then this may not necessarily count as harm if the wife was warned before. Also, the marital rape in Egypt is not regarded as a crime in the law. In legal and social terms, marriage is understood as an institution in which women are obliged to provide sex to men whenever the husband requires it. However, a landmark law was adopted in 2000 in Egypt, and it provided women a new divorce option without any need to prove harm. Safeguarded by an Islamic concept known as khula, women gained a right to a no-fault divorce by forfeiting their financial rights in the marriage. So this, in theory, gave women the right to ask for a divorce without the consent of their husband and without a justified reason. And, however, women who file for this kind of divorce have to renounce all their financial rights from the marriage, and they cannot claim alimony, nafaka. So, khula, in theory, and its application, let's say, however, khula, in theory and application, couldn't end women's secondary position in marriage and divorce in Egypt, because only financially stable women can use this right. It has only provided those women with financial means a faster exit from unwanted and abusive marriages. Also, it is, let's remember this. During the harm-based divorce litigations in Egypt, which takes a very long time, up to 10 years, according to my interviews, men do remarry. So men remarry and have new children. Their lives go on during the divorce litigations, harm-based divorce litigations. As opposed to that, long years of divorce litigations bring women's lives to a halt. They cannot remarry, they cannot continue their lives. They are financially unstable. Therefore, even when women have acceptable reasons to divorce based on harm, and even if they are entitled to keep their financial benefits otherwise, many of the women began to file a khula divorce to fasten the process. So we see this from the testimonies coming from Egypt. Let's look at Palestine. Khula divorce is applied in West Bank, but in this format, it necessitates the approval of both parties. So husbands should give consent to the divorce. So basically, it's a consensual divorce agreement. This is what khula means in West Bank. In Gaza, this procedure is not mentioned in the existing personal status laws. However, the judge may permit this form of divorce if the wife pays a specific amount of money to compensate the husband. Yes, let's come to another important issue where women are discriminated against. It is the concept of polygyny, male polygamy. While men can have multiple wives, women cannot have multiple husbands. This puts women, the fact that men can remarry during the marriage, puts women to a secondary position in relationships and marriages, psychologically, legally, and financially. So in Egypt, the law number 100 of 1985 has protected the right of women to divorce, whose husband step into polygyny. But basically now women have to prove the material or moral damage they suffered. So they have to prove the harm they suffered during polygamy if they want to have a harm-based divorce. Women have to apply for a divorce within 1 year from the date she finds out about her husband's remarriage. Basically, the ambiguity of the definition of harm in this law has given the judges a great discretionary power. Women need to prove the damage they have suffered with at least 2 witnesses, and there is no guarantee that they would be divorced they would be divorced from their husband who marries someone else. And again, litigation could take several years and is financially burdensome. Overall, while the repealed 1979 law in Egypt and the new or the recent 1985 law in force did not limit male polygamy, they simply granted the first wife or existing wives any reason of harm for divorce. Let's look at how polygyny is applied in West Bank and Gaza. The practice of polygamy is also permitted within the Palestinian context. And according to the survey from 2014, Palestinian Multiple Indicators Survey, polygamy is estimated to be 4.5% among all marriages in Palestine. However, we can say that economic situation in both the West Bank and Gaza is getting worse, so it is hard for men to marry and support more than one wife. However, even in this case, it is reported a rise of polygamous marriages in Gaza, especially due to the occupation and due to the war that increased the number of female widows in Gaza. In both, in neither context, the consent of the wives is required. Only the husband has to, in West Bank, an authorized marriage officer must inform a prospective bride that her prospective husband is already married, and also the officer must inform the existing wives. In Gaza as well, it is suggested, there is no written law on that, but it is suggested by the Supreme Council of Sharia judiciary that informing the existing wives should be a must, but again, it is not in the law, so it is still discretionary. What is important here, actually, women have the right to stipulate conditions in their marriage contracts in Egypt, in Gaza, and West Bank. However, this right is not commonly applied because there is a big stigma around putting stimulation in the marriage contracts, especially for younger girls. So it is regarded as a bad omen for young brides if they want to put stipulations in their marriage contract that their husbands cannot remarry, or they have the automatic right to divorce if they remarry. So they don't really use this right. Okay, I'm coming slowly to the end. Also, Egypt and Palestinian Authority has accepted CEDAW, Convention of Elimination of Discrimination Against Women, International Human Rights Framework. Egypt has reservations as some of the equality conditions in CEDAW contradicts PSL, contradicts Personal Status Law. However, Palestine accepted it without reservations. Nevertheless, because laws that are Sharia-based often takes precedence in Palestine as well, when there's a conflict between CEDAW and existing personal status law, the personal status law supersedes. Before finishing my presentation,
5 minutes, Ms. Aslı.
Thank you very much. I'm finishing. Yes, so basically, as you might know, there has been recent proposals in Egypt to reform the personal status law. However, they were regarded as very conservative, according to many Egyptian feminist groups, and they protested against the new reform packages. And they somehow managed to influence the political elite to stop passing off the bills that were against women. They call on lawmakers to ensure that the law should regard women as having full legal capacity, and thereby giving them equal rights and duties within family as men. Regarding marriage, also women in Egypt ask that divorce should be legalized only through a judge, and that polygamy should be allowed only through a judge authorization following permission from a man's first wife. So it should be with the permission of the first wife. Of course, here we see that majority of the women's activists in Egypt, at least when they speak, they aim to limit existing practice of polygamy rather than they demand to ban it publicly. We can discuss why this is the case. About Palestine, as Suhair Azuni states, all discussions about Palestine's constitutions, its laws, their impact on women must also address the limitations imposed by the Israeli occupation, which heavily influences the way Palestinians conduct their daily lives and personal affairs. End of quote. There was an increased Islamization of the political discourse in Palestine since 1967 war with Israel, and with the rise of Hamas in Gaza after 2006 elections. Observers report that the process of Islamization in the occupied territories and the current incoherence of a divided structure of governance affected by the occupation and coupled with the absence of Palestinian Legislative Council have created a vacuum in any authoritative regulation of Palestinian affairs. And this vacuum has been filled by customary law and practices which are often disadvantageous to women. Let me finish with some notes from Egypt. According to several Egyptian activists, the problem with the existing personal status laws is not that it is based on the Sharia. They argue that regardless of the source of the law, the content of it can be revised with scientific and religious research. For Egyptian activists, both fiqh, Islamic jurisprudence, and international conventions are tools for them to fight for their case. Similarly, the lawyers I talked to who work on women's issues argue that fiqh is not untouchable and that it's reformable. Activists highlight that embedded cultural stereotypes, economic hardships, and long judicial processes make divorce for Egyptian women difficult rather than the source of the law. However, Comparison with countries without religious-based personal status law, such as Turkey, makes it clear that the legal institutionalization of religion renders the personal status law reform much more difficult. The historical resistance of religious authorities to leave their grip in the only domain that they can control has been stalling and delegitimizing women's reform attempts. Hulla experience in Egypt shows that reform proposals of women based on Islamic ijtihad was not sufficient to legitimize the reforms in the eyes of clergy, conservative judges, and society. Religious and cultural stereotypes about divorced women also make it difficult for them to use their legal rights, even the ones sanctioned by religion. Furthermore, among the women activists, few have the knowledge and authority to talk about religion in a systematic way. Women's rights activists feel more comfortable staying within the human rights discourse. However, they often point out the necessity to get prepared for religious discourse. This issue leads us to women's right to do ijtihad, new religious reading, and women's right to contribute to the religious discourse. And finally, this reminds me of Nazira Zeyneddin of Lebanon from 1920s. Nazira Zeyneddin, as a young woman, challenged elderly male religious leaders with her own religious interpretations. The activists today in Egypt and Palestine who try to produce an Islamic legal discourse and claim their right to ijtihad carry the spirit of Nazira Zeyneddin to today, however, still without much success. We see that the sacred character that is attached to personal status laws, but more importantly, the grip of the religious leaders and officials in the MENA, and political concessions of the authoritarian regimes to religious groups are blocking the reform attempts of women who want to have a more equal relationship in their marriages. Thank you very much.
Thank you, Aslı.
That's
Thank you
it.
very much.
Thank you.